Okay, so in the actions for failure to act, we will be using some of the grounds we have mentioned for an action for annulment. Do you remember the grounds for an action for annulment? We will be using some of them in the actions for failure to act. Which ones can we use? Yes?
Maybe infringement of the founding treaties or any other rule of law.
Yes, that is very general, isn't it? So infringement of the founding treaties and any other rule of law relating to their application. We can use that. Infringement of the founding treaties or any other rule of law relating to their application. What else? Can we use lack of competence?
No.
We can't because there is no act here. Can we use misuse of powers?
No.
Why not?
Maybe.
Yes?
Because we said that for misuse of powers, this one act should have been adopted under an article that is not. So if we are not doing anything, then why should we act under an article? We're not acting at all.
Yes?
Or maybe I thought that failure to act is also an act in itself. So.
No, failure to act is non-action.
Okay.
But there is, yes, Dennis?
Maybe institutions had a choice of adopting an act, and it should have adopted that, but it didn't, because it also had the choice to not to adopt. But according to the situation, it would be it would make more sense if it should have adopted. So that would be a misuse of a power too.
Okay. In the misuse of powers, there is an act on a wrong provision. How about there is no act on the right provision, under the right provision? So misuse of powers may be used here. How about infringement of an essential procedural requirement?
Yes. Because if there is a procedure should be taken, and a new institution don't take this procedure, then it might be, I think.
No, in the infringement of a procedural requirement, there is an action. Okay? There is an action which infringes the procedure. Therefore, we don't use it. Yes?
I thought it was questions.
No. All right, so we use misuse of powers and infringement of the founding treaties or any other rule of law relating to their application. There is also a time limit in the actions for failure to act. But it is different than an action for annulment here, because there is no act. When there is failure to act, first is to call that institution to act. Therefore, the institution concerned is first called upon to act. If that institution does not act within a 2 months period, then an action can be taken before the Court of Justice within the next 2 months period. The institution is therefore first called upon to act. If it acts within a 2 months period, no problem. But if the institution does not act within a 2 months period, then there will be another 2 months to take an action before the Court of Justice. All right? If the court determines a failure, that it cannot remedy that failure. Remedy? But the institution concerned has to take the necessary measures to remedy that failure itself. The court does not do anything, only determines the failure. Then we have actions for damages. Actions for damages. In Turkish, tazminat davaları. According to the founding treaties, Article 268 and 340, paragraph 2 of the Treaty on the Functioning of the EU, paragraph in Turkish?
Bölüm.
Fıkra. Article, madde. Paragraph, fıkra. Band, subparagraph. According to the founding treaties, in case of non-contractual liability, in the area of non-contractual liability, in Turkish, sözleşme dışı sorumluluk alanı. In the area of non-contractual liability, the EU shall make good any damage. The EU shall make good any damage caused by its institutions or by its servants in the performance of their duties. The EU shall make good any damage caused by its institutions and by its servants in the performance of their duties. Again, according to the founding treaties, the EU or the principles, the general principles common to the laws of the member states shall apply. The general principles common to the laws of the member states shall apply. This means that the damage shall be compensated according to the general principles common to the laws of the member states. For this provision to be applied, as you would see, the damage should have been given by an EU institution or by a servant of the European Union in the performance of their duties. This provision, which is different than the others, tells us the law applicable by the Court of Justice. Can you see that? The law applicable? Or the applicable law?
Yes.
What does it say?
The general principles common to the laws of the member states.
Exactly. The provision itself tells us that when dealing with these type of disputes, the Court of Justice has to look at the laws of the member states and determines certain common principles that exist in those member states to solve this specific dispute. Therefore, in practice, when dealing with this type of actions, the Court of Justice looks at the laws of the member states to figure out what is fault, for example. What is fault? What is illegal action? What is causal link? Causal link? What is causal link? Or what is the amount of compensation to be paid in these type of actions? It is not like finding German law or finding German rules in these cases and applying it to the specific case. It is not like that. It is like looking at all the laws of the member states, the national laws, and trying to find some general principles which are common in those member states to solve an action for damages. Therefore, this is a different provision telling us how the Court of Justice will solve this type of dispute. All right?
So, do the decisions rely on, the case law of the Court of Justice? Because the Court of Justice develops its law by looking at the common laws of the member.
What do you mean?
Is it the case law?
Which case law? The case law of national courts?
No, it is the case law of Court of Justice of the European Union. It develops the case law by looking at the laws of member states, and it decides on the actions for damages.
Exactly, but the thing is that the first is the court develops general principles as well for European Union law by looking at the national laws of the member states, okay? So yes, there is a case law of the Court of Justice that is developed by the court. But the decisions of the Court of Justice is binding for everyone, for all the courts, for all the national authorities, but the court itself, okay? The court's decisions do not establish precedents for the court itself. Precedents? Emsal. Therefore, only the court itself, the Court of Justice, is not bound by its previous decisions. Why not? Well, it has to develop European Union law. If we say that the court is bound by its previous decisions, then we cannot, or the court cannot change its previous decisions when the time changes. This is a new legal system. It has to be developed, and the main institution that can develop this legal system is the Court of Justice. It has the sole power of interpretation. Okay, so yes, the court adopts certain rules to be followed by itself in the coming actions, but still its previous decisions are not binding for it. All right?
But binding for other courts.
For everyone. For everyone. Okay? Mm-hmm. Of course, in the member states, the national courts, the national authorities, the individuals in the member states, everyone. Okay. The next type of action is staff cases. Staff cases. Please read from your books again. I will be giving the general aspects of certain actions from now on. I will be explaining the preliminary ruling procedure in detail. Others shall be read from the book. The staff actions or the staff cases are between the staff of the EU and the EU. These include disputes both on questions of working relations in the strict sense, including the pay, career progress, or recruitment measures, or disciplinary measures. Therefore, it could be about the working conditions, or it could be about the problems regarding social security system, such as old age, or invalidity, or accidents at work. Then we have actions arising from the Statute of European Central Bank and European Investment Bank. European Investment Bank and European Central Bank. Statute means statute in Turkish, statü. What is that? It could be, it is statute, but it is the legal document
That explains the working.
that establishes that institution. Therefore, the statutes of European Central Bank and European Investment Bank provides for the jurisdiction of the Court of Justice as regards disputes, or as regards the following disputes. First, as regards the obligations of the member states under the Statute of European Investment Bank, as regards measures adopted by the Board of Governors and Board of Directors of the European Investment Bank, and arising from the obligations of the national central banks of the member states, arising from the Statute of European Central Bank. Yes?
May I ask one question? As far as I know, there was a case between Italy and European Union last year, because I don't know the exact case about it, but there are some limits for member states to put the GDP level at one number, or at a number, at a specific number. Do this type of actions include actions arising from Statute of European Central Bank? Or?
We have to look. It can be anything and everything. If it is like Italy versus European...
I didn't see the case, but
we have to look
about it, because Italy didn't comply with the limits of GDP last year, because there is a limit of 2 points.
It could have been provided in the Statute of European Central Bank, and if it may be about the obligation of a member state national central bank. This could be based on this one, but we really have to look at that case to figure out. It can be any other case as well. Okay. We also have the next one. The actions against money judgments. The actions against money judgments. As you would remember, the European Commission has the power to issue fines in some sectors, such as competition. You might remember that we have spoken about this power of the European Commission. The European Commission is the executive organ, but we said that it has some judicial functions too. And as one of the judicial functions, we have mentioned that the Commission has the power to issue fines in some sectors, such as competition. To issue fine? Exactly, fine, para cezası. Certain EU regulations provide for this power of the European Commission to issue fines. And this power of the European Commission is controlled by the Court of Justice under the actions on money judgments. So the European Commission's power to issue fines is controlled by this type of action according to the founding treaties. Okay, the legality of these fines are controlled, are reviewed by the Court of Justice. The last type of action is the preliminary rulings procedure. This is one of the most important type of actions, I would say, but there is no real action here before the Court of Justice. The preliminary rulings procedure is provided under Article 267 of the Treaty on the Functioning of the European Union. ideas? Anyone? Has anyone read about the preliminary rulings procedure? What is that in Turkish? Ön karar usulü. What could this be? We have mentioned this once, I think.
We said that it's the unique tool of the Court of Justice for the jurisdiction of the Court of Justice.
And? Yes, Deniz?
There were some exceptions. I mean, as far as I know, the general court can make preliminary ruling procedure.
No. The General Court has jurisdiction as well for this, but it does not exercise its jurisdiction. It is the Court of Justice still that exercises the jurisdiction as regards the preliminary rulings procedure. Yes, Atakan?
It says that in some cases there has to be first, before it comes to the Court of Justice, it should be seen in national courts or tribunal courts. Or tribunals.
Yes, and?
And then only then after it's seen in those courts, it can be brought to the Court of Justice.
So what is preliminary rulings procedure?
Yes.
Oh, no. No. There is the national court's involvement here, but it is not that. Okay, this is the preliminary rulings procedure is a tool for providing cooperation between national courts and the Court of Justice. The main function of this procedure is to provide uniform interpretation of EU law. To provide uniform interpretation of EU law. Interpretation of EU law. It is an indirect procedure, meaning that the main dispute is not before the Court of Justice, but before the national court. Therefore, the parties of the action, plaintiff, takes the action before the national court. Why not before the Court of Justice? Yes, Deniz?
There is similar procedure in our system, I think, for the times of...
No. Why does a plaintiff take an action before the national court and not before the EU court? Very easy answer.
Because of sovereignty?
No?
Maybe it is stated in the founding treaty.
No?
It's like a European Court of Human Rights. It's
No?
like a domestic.
No? Because the Court of Justice has no jurisdiction. Basically, for the type of actions provided under the founding treaties for the Court of Justice, can we go to the national courts? Why not? You know, bravo, it's exclusive jurisdiction. Exclusive jurisdiction of the Court of Justice, what would that mean?
Only the Court of Justice.
It means these actions we have been speaking about can only be seen by the Court of Justice and not by any national court or by international court. It is only the Court of Justice. If a national court, for example, deals with an action for infringement, would this have any legal effect? No legal effect at all. Therefore, this means the exclusive jurisdiction of the Court of Justice. If the Court of Justice has no jurisdiction on a given case, for example, we have a contract with or two individuals have a contract between each other and this is related with European Union law. Even if it is related with EU law, can the plaintiff go to the Court of Justice for a dispute to be solved? No, it is not under the jurisdiction of the Court of Justice. We know the actions under the jurisdiction of the Court of Justice. Is that true? Yes, we have been dealing with that. Therefore, imagine that two persons having Belgian nationality, they have a dispute between them arising from EU law. Where would they go? The national court. Therefore, the national courts also apply European Union law, of course, when there are disputes before them arising from EU law. Therefore, in the preliminary rulings procedure is that the dispute is before the national courts. The national courts of the member states may also apply, of course, European Union law when they are solving the disputes. Okay? If a national court, when solving a dispute from European Union law or when applying EU law to a case before it, may face with two different problems. It may face with question of interpretation, the question of interpretation, or it may face with question of validity. It is applying European Union law, it wants to apply EU law, and it faces with a question of interpretation. This could be interpretation of founding treaties. This could be interpretation of acts of EU institutions, bodies, or agencies of the European Union. Imagine that national court, say a Belgian court dealing with a dispute between two Belgian persons, may need to apply European Union law and may face with a question of interpretation of EU law. Okay? Or it may face with a question of validity of binding secondary EU legislation. It may face with a question of validity of binding secondary EU legislation of EU institutions, bodies, and agencies. What will it do? For instance, if that Belgian court faces with a question of interpretation of the term worker in the founding treaties relating with the free movement of workers. We know free movement of workers as one of the fundamentals of the European Union, and we will be seeing that. In the founding treaties, the free movement of workers are provided very detailed, but there is no definition of the term worker. The Belgian court here thinks whether a trainee lawyer is a worker or not. The plaintiff says that he is a trainee lawyer working in a law firm, and he claims that he has the freedom of workers. He can exercise the freedom of workers under the founding treaties. And the employer thinks that he cannot be considered as a worker. So the dispute is before the Belgian court. Can the Belgian court interpret the term worker in the founding treaties? Yes?
No, because we said that the Court of Justice has the sole power to interpret the EU law, and the National Court is not the Court of Justice.
Yes, in terms of capability, of course a court can interpret a term. But here, as far as European Union law is concerned, the interpretation of EU law has to be uniform and binding for all the member states, because you are developing a legal system for 28 member states. Okay? Therefore, this uniform interpretation cannot be made by any national law, but by the European Court of Justice. So, in these two types of questions, both on the questions of interpretation of EU law and not about question of interpretation of national law, and on the questions of validity of EU law, the national court shall stay the proceedings and shall refer these questions to the Court of Justice. It will ask, if it is a question of interpretation, it will ask clearly to the Court of Justice. It will ask, for example, how do you define the term worker under the founding treaties? Give me a definition. It is drafted as real questions from the national courts to the Court of Justice, or it will ask whether an EU instrument, a regulation, is still valid or not. And it will send these questions to the Court of Justice. Technically, we say it shall refer the questions, or it shall make a reference, or it shall make a preliminary reference to the Court of Justice, meaning it shall ask these questions to the Court of Justice. To stay proceedings in Turkish, it shall stay the proceedings, I said. Shall stay the proceedings and refer the case to the Court of Justice. Bekletici mesele yapmak, bekletici sorun. It shall stay, it shall wait, it shall not deal with a dispute, and it will ask to the Court of Justice. The Court of Justice will give a binding decision. But before that, there are two important things. First, as you might have realized, I did not say a preliminary rulings case or a preliminary rulings action. In other type of actions, we said action. There is a case. Here we say preliminary rulings procedure. Why?
This is not a case that is solved by the Court of Justice.
Yes, exactly. This is not a real action to be solved by the Court of Justice. Who will solve this action? Who will solve this case? It will be the national court. Here, the Court of Justice will make a decision, will give a ruling, will give an opinion, which is binding on the national court. It will send its decision to the court, to the national court, and that national court, the Belgian court here, shall solve the dispute according to this opinion of the Court of Justice. For example, the Court of Justice shall give a general definition of the term worker, and the Belgian court will say, okay, trainee lawyers then will be considered as workers as well. Okay? For instance, as you will be seeing later when we speak about free movement of workers, the Court of Justice gave a definition of the term worker, saying that a worker is a person working under the supervision of another person under an employment contract and which receives remuneration in return. But then, in a following case, there was a problem whether remuneration in Turkish? Karşılık would only include payments, money payments, or, for instance, would accommodation and free lunch be considered as remuneration as well? The national court cannot find it itself in the decisions of the Court of Justice. It will make another reference. It will make another application according to the preliminary rulings procedure. Another issue is that We said that the national courts, according to the founding treaties, it is national courts or tribunals, it say. The national courts or tribunals can make a preliminary reference to the Court of Justice. The question is that, what is a court or a tribunal? What is a court or tribunal? A member state has established an institution which is called as court in that member state. Can this make an application or can it refer a case to the Court of Justice under this procedure? Would it be sufficient if a national law calls an institution a court or a tribunal? This is not clear in the founding treaties. There is no provision about this in the founding treaties. But the Court of Justice has important decisions about that. According to the court, under its different decisions, a national court or tribunal has to fulfill the following requirements. First, its jurisdiction must be compulsory. Its jurisdiction must be compulsory. In Turkish, zorunlu yetki. Meaning? No, we will say it as a second characteristic. But what was it? We've discussed it here, a compulsory jurisdiction, yes?
It should be constituted as a default code in the constitutional.
No, what did we say? Yes? No, we didn't say that. We said something else for compulsory jurisdiction. We said that the court shall have jurisdiction independent from the will, consent, or recognition of the parties. Therefore, the national court should have compulsory jurisdiction. Second, it should have been established by law. Third, it must be permanent in Turkish. Daimi. Permanent, meaning not ad hoc. Not ad hoc. Ad hoc? How could it be possible ad hoc? Yes?
Adalet divanı in Turkey, I guess, only come together when there is a certain event that's happened with the president.
Ad hoc courts and tribunals, if you mean this one, only meet when there is a dispute to solve certain disputes. And then disappear or dissolve, yes. But for national courts to be considered here, it must be permanent. It must be independent. It must apply the rule of law. And it must deal with issues inter partes. Inter partes.
How do we write that?
Sorry?
How do we write
inter partes? Exactly. Inter partes. Mm-hmm. Okay. This is it for today. I will release you now, and we meet on Wednesday.